So welcome back to the big discussion, and of course the focus has been on the best escape that the country has been watching for months now as those proceedings unfold in court. Slee, let's bring you back in here. As we mentioned at the beginning of the discussion, you have been central to following the drama that has ensued, if you will, the stuff of movies really, but there are 9 other people that were in the dock with Nandipha Magudumane, and they've all applied for bail, and she is only doing that now. Perhaps break down that process for us and the status, if you will, of the other 9 accused.
So we know, of course, in total 12 people have been arrested for the escape, including Thabo Bester. Now, 9 of those make up, of course, of Nandipha's father, as well as former and suspended G4S employees who were working at the prison at the time of the escape. They have all, on different occasions, applied for bail, and they've all been released on 10,000 Rand bail. And I think what was something that the state was trying to show the court was that why is it that Nandipha has waited at least 4 months to apply for bail? And we know in that 4 months that she's approached the higher courts here in Bloemfontein to have her arrest and deportation declared unlawful and set aside, which was something that the state also brought up, saying that Nandipha's contention that, she's going to be in custody for a long time and that's why she should be released shouldn't even be considered, because she's the one who waited 4 months to actually launch this bail application. So one of the arguments also brought forward by her lawyers was that 9 other people who have been implicated in this escape have been released.
So, Mpumelelo, just on that point, before the break, we had put to the viewers a point that Elton made, that should it be denied, she might have the opportunity to appeal that particular court decision. Perhaps break that likelihood down for us and what exactly she would then have to put forward when appealing, because it would have to be, as Elton alluded to, quite the compelling and transparent argument.
Basically, she would have to say, a reasonable presiding officer in the shoes of the presiding officer that was listening to my case should have foreseen that if you apply the correct application of what is written in terms of Section 6 of the Criminal Procedure Act, I'm a perfect candidate to be released on bail. So I should be released on bail with all the conditions that should be there. I always say bail applications are the most easiest, at the same time most hardest applications to do. Easy in this sense, you have your Section 6 of the Criminal Procedure Act that goes line by line or question by question of the information which is required. However, the difficulty is finding answers to those questions which are going to be able to convince the presiding officer. 2 important points. If you look at the gravity of the charges, you look at the gravity of the sentence that might be issued if she is found guilty. And the last one, which appears on almost each and every single section under Section 60, of saying that the court will then look at any other factor which, in the opinion of the court, is important. Now, you can't think on behalf of the court and you don't know what other factor in which they're going to look at. That makes the chances of you being refused bail quite high. But there's always a reprieve to that. You can always appeal to the High Court, get the record from the magistrate court in which you were in, submit it into the High Court and highlight instances in which we are going to say this magistrate would have erred. A record is then given to the magistrate to get her right of reply, and after that a judge will then sit and rehear the matter or apply their mind. Most of the time you'd find that, as you've seen as it has happened in this case, that when you go to the High Court has a completely different approach to bail application. They simply say, we want to uphold and protect your right to innocence as much as we can, and if there are preventative measures or stoppages that we can put in place to make sure that you don't evade trial, you don't interfere with any witnesses or any evidence that is there, we are going to put them in. Maybe like saying you must go and sign each and every single day within your nearest police station, submit your passport, and then make sure that you're able to report on a regular basis to the investigating officer. So those are all things that can come in, but it does not mean that if she's denied bail tomorrow, it would be the end of the road. It means that she has an opportunity to go to the High Court. The only bad part about it is that it's going to take time. And while that particular time is taking place, unfortunately, she will be behind bars.
And that's the big thing, Elton, because if she does get bail, there is a possibility that she does violate the conditions that you spoke about earlier on. And the biggest one here that has been bandied about is the fact that she's a flight risk. She's had access to different passports and aliases, and the list goes on. Should she get bail and she is not flying anywhere, what are the, in your experience, if you will, what have you seen on the revocation of that bail? Does it happen often where it does get revoked?
No, obviously, cancellation of bail, it happens daily in courts, where people violate their bail conditions. Then the prosecutor will bring an application to say, we're going to cancel your bail, and then you being kept in custody until your trial has been finalized. So this happens on a daily basis. We just don't see it because it's not reported, but it's a common occurrence, and this can happen. And for her, maybe they should have also actually said to the court what conditions the court should actually consider in actually applying to them. And I would, if I was the legal representative there, I would have told her, you can even put like this ankle monitor on me to see actually where I am at any given stage. So then the court will say, okay, you are willing to subject yourself to this, and this means you are constantly, because that monitor, the moment you go close to a border, it sends a signal off. So I would have put in all these things to say I'm willing for this, that, and the other to happen. Also give a little bit of my defense, a little bit, but calculate what am I giving, so that at trial stage I'm not actually now prejudiced if there's evidence that's brought that cannot really challenge or add to my defense. So in that scenario, I would have gone that route to also take the court and say, listen, your court, I'm willing to negotiate with you subtly by giving these types of things. And that is one of the things. And if she's given bail, then obviously the strict conditions will be there. And then obviously the investigating officer is now tasked with actually monitoring to make sure that she adheres to these conditions, also keeping in touch with the state witnesses so that she doesn't directly or indirectly influence them. Because obviously I can say to your reviewer, can you phone Slee to tell her to drop the charges? That's indirectly. So I'm not even supposed to do that. So the investigating officers, if she's released on bail, I think he's going to have a headache, because Nandipha, being the girl she is, I think...
Very resourceful.
She's very resourceful.
Yeah, and just on Mpumelelo's point earlier about it being heard at the High Court and then again being denied and then her remaining in jail, what does this mean for the actual commencing of the trial? Does this mean further delays as we see these applications for bail and so on go forth?
No, it can't. It can't deny the actual trial. Yes, obviously, when we get to a point where we say the investigation is complete. Once the investigation is complete, now the magistrate can set a time roster as to we need to have a pre-trial, we need to have discovery, we need to do all sorts of things. He can set a time roster to the legal practitioners involved in the matter to actually get this case moving. Bail application, you can bring bail application at every given stage while we're even busy with the trial. If new facts arose or arise at some stage, you can bring a fresh bail application. So she can wait, and maybe 6 months down the line, new facts emerge and stuff like. She can bring a fresh bail application, a bail application on new facts. So it doesn't stop. These processes can run parallel, but I think some people would normally want the application to halt the entire trial so that they don't get to that point, maybe in a hope some of the witnesses will disappear, either dying or not interested in coming to testify, and eventually then the state won't have sufficient witnesses to prove their case. That's more or less sometimes how people play it, but it's all tricks and strategies that is being used in the legal field.
Yeah, that's very interesting. Mpumelelo, I mean, if she did get bail on Monday, as we've been reporting, would this speak to the strength or perhaps the weakness of the state's case?
I don't think it would have an impact on any. Remember that when you're doing your bail application, you are not really concerned about the merits. Remember, there's no evidence that has been led, so there are no witnesses that have came into the witness box and testified as to how guilty she is or how innocent that she is. So the only test which was being done by the court was the proceedings of saying, is it in the interest of justice to be released? Let's look at what Section 60 of the Criminal Procedure Act is saying and check whether you are a perfect candidate to be released on bail. The trial stage is yet to come. That's when it's going to matter as to what the evidence is. That's when it's going to matter as what the witnesses are. That's when it's going to matter as the sequence of events and the manner in which you are presenting that evidence. And also the defense that you are coming with, that you're saying, is it a probable defense? Is it something that we can be able to believe in? Is it something in which you are then going to say it was completely something beyond your control? As we've had snippets of a defense during this bail application to say, does it suffice to say I was coerced or I was forced? And yet a few months down the line, you do not act as if you're a person who has been coerced. So at what point did that element of being coerced end? And why didn't you take the necessary step of applying for bail even when you landed in South Africa? Why it takes so long? Yes, it's within the prerogative of you as an individual. And maybe you can come back and say, that's the legal advice in which I've received. I'm a medical doctor, I'm not a legal practitioner. But at the end of the day, those are the type of questions which are going to be discussed. But when it comes to the trial and when it matters the most and where most evidence is going to come into the fore and be scrutinized by the court is during the trial stage and not during the bail application stage.
And it muddies the waters, Elton, because you clarified this for us the last time we had this discussion, that there's a clear distinction between her case around the deportation or the extradition of her back into South Africa, and then, of course, the bail application. But I say it muddies the water in the sense that, on the one hand, she's saying she was kidnapped by Thabo Bester. On the other hand, she's claiming that she was kidnapped by law enforcement authorities. How do you make sense of those particular contradicting arguments that have been put forward over the last few months?
If I look, and I now am going to try and be telepathic and get into the mind of Nandipha here. So Nandipha said there was 2 crimes that was committed against her. First, by Thabo Bester, kidnapping her from South Africa to Tanzania, or through Zimbabwe up into Tanzania. And then she says, then somehow somebody rescued her. And it's the Tanzanian officials who says now, okay, you're not supposed to be here. And now the South Africans rock up in Tanzania and they kidnap her from Tanzania back to South Africa, where she was originally kidnapped from. So these are 2 sort of half kidnapping instances in her mind. And she's saying, okay, I did not give consent for Thabo to take me to Tanzania, and I did not give them consent to bring me back. So she's saying in both instances there's a lack of consent in these 2. But she says, okay, when Thabo takes me to Tanzania, and now I'm being freed by the Tanzanian authorities, I'm now out of his clutches. I now need to have a choice as to where do I want to go. Do I want to go to United States of America, Dubai, Russia, Ukraine, wherever? I don't want to be dictated by the South African authorities to say, listen, you have to come back to South Africa. So, and that's where this one here by Thabo, it's a criminal charge in terms of South African law, but it can also be a criminal charge in Zimbabwe, in Tanzania, where he's kidnapping her. And now we talk about from taking her from Tanzania is now extradition, bringing her back to South Africa, which is a constitutional issue on that side, to say, now you've been breaching our constitutional or my constitutional rights from taking me without my consent from a country where I was now free from the clutches of Thabo Bester, where I had a choice to either go anywhere, and you forced me to come back to South Africa, and you now sort of half say, I said I want to see my children, and that's where we need to sort of half sever. It's something that comes from one thing, one event that led to the other, but we can easily dismantle it and say this part here can be an additional charge that can be added to Thabo's charge sheet in South Africa for kidnapping her, but then it means that she had to actually open a case in a South African police station where she was kidnapped for the first time, and then that
Which
can
she
be...
still hasn't done, by the way. She has not laid charges against
She
Bester.
hasn't done so, but obviously one can also say, if I know my person that is most probably kidnapping and maybe pushing fear into me, he can harm or do something to me, I will not do so, because I think that is what she's trying to say, out of fear, she did not actually go and open a case against Thabo Bester as yet.
Yeah.
Maybe if at some stage she's out of fear, which I don't know when it's going to end, but that's for her to come and tell us when she's out of fear, then she can open that case to say, okay, I'm now opening an abduction case or a kidnapping case against Thabo Bester. Most probably then one can, but if she have done it like the moment she arrived in South Africa, it would have helped her bail application come to this day. But that one of the extradition, and the High Court now did not help the case.
Yes.
Judge Loopholes actually made a fact finding to say, listen here, this was a disguised extradition. So that prickly pear, it's now for the SCA to deal with, but the bail application, that's it. If this is here, these extradition proceedings, they could have most probably used it already in the bail application, but I think they did not use it as I think they could have used it, but obviously the magistrate still has to decide, is she a candidate for bail or not?
Yeah. Ashley, I'm going to wrap up with you in a moment, but Mpumelelo, just weighing in on what Elton said there, the nuances that he's just described, are there any loopholes, legal loopholes, if you will, very briefly, that her legal team may take advantage of, perhaps in their in proceedings going forward, taking into account the fact that she actually hasn't even laid charges against Thabo Bester as yet?
I don't think they are. I think the extradition application was they were trying to find a trump card, or they were trying to go for the jugular, and to say that if we are successful on this one, then we're not going to proceed over to the criminal proceedings, which are going to come at a later stage. But due to the occurrence of time and maybe the pressure that they were receiving from their client, they then said, okay, let's apply for bail. This is what we are going to state. Even not on the defense and the she's provided now, I do not see that as a defense enough, because if you say you are kidnapped, then a reasonable person in your shoes, if you are kidnapped, you come back, and as soon as you attain freedom, the first thing that you are going to do when you are faced with authorities, you are going to disclose all and say, let me tell you how this particular process took place. I wasn't part and parcel of it. I did not give active consent. I was actually forced into engaging into this type of things. In fact, I want to help you, so let me become a state witness so that you can be able to get the true criminal and make sure that you're able to punish them. Maybe at a later stage, she may turn a state witness and maybe have a plea and sentence agreement. And part of that agreement would be make sure that you give evidence which is crucial so that you can be able to bring those that were involved to book, and then you'll be able to let free or get a lesser sentence. But in all the attempts that she's made to exonerate herself, I do not think those attempts are strong enough in order for her to be given a not guilty plea.
With that then, as a final word, what are we expecting to get underway in court? But also, in your thoughts, did it help that her family was actually there during those previous court proceedings? We haven't seen much of them supporting her apart from the last couple of appearances. And like I say, what is set to proceed in the process on Monday?
So what we are expecting, of course, tomorrow is the judgment in her bail application. We are, of course, expecting her family to be here as well. But the big appearance will be on the 11th of October, where we are expecting all 12 accused back in the dock. We did hear from the state in the last appearance in August that they are finalizing the investigations, and perhaps we will be getting more clarity as to when this matter will finally go to trial. But we've also heard from the police on numerous occasions that they have not ruled out the possibility of more arrests. So I think that's what's going to be interesting to see between now and October, is if anyone else will be joining the 12 accused who are already in the dock.
Thank you very much, Silindelo, Masikane, Mpumelelo, Zikalala, Elton Hart, for joining us for that big discussion. We've got your headlines coming up shortly. Do stay with us.